Happy Monday, and welcome to the latest in our webinar series, the 2024 OSHA webinar series here at ConMACL Cary. Today, we are going to be presenting on process safety update, the latest with OSHA PSM, EPA, RMP, the CSB, and my colleague Andrea Chavez and myself will be giving you also some updates on their California counterparts. So I am joined today by many of my colleagues, and I'll introduce them to you in a second. My name is Rachel Kahn. I'm a partner and chair of ConMACL Cary's California practice. So I specialize in CalOSHA, and we have certainly been seeing an increase in PSM inspections. And so we are excited to talk a little bit about that later on today. And then also some of my other colleagues that are joining me today. We have Valerie with me, who is a senior counsel in our Detroit office. And Valerie is the PSM expert and guru. So I'm very excited to hear about all of the updates that she's going to be providing to us on today's webinar as well. And Bita, who is in our Washington, D.C. office and a specialist in everything chemical safety and hazard related. And she's also going to give us some of those updates on, what's happening at the CSB. And then we will also be joined by Andrea Chavez, who is a senior counsel in our LA office. And she and I are going to be walking you through what's the latest happening out here in California. So our agenda, Valerie is going to kick us off with the EPA's new final RMP amendments and PSM updates. Bita is going to be sharing with us the proposed emergency response rule and how that intertwines, and the chemical safety board updates. And then we'll be finishing out with the CalOSHA updates as well. And with that, I'm going to turn it over to Valerie.
Thank you, Rachel. And hi, everyone. Thanks so much for joining us today. We've got a lot to get through, so I'm just going to jump right in. In March of this year, to give greater protections to people working and living near chemical facilities that have tended to have high accident rates, EPA's administrator signed the Safer Communities by Chemical Accident Prevention Rule, which finalized major amendments to EPA's Risk Management Program rule. This may change, and I'll get into what I mean later, but for now, employers have 3 years to come into compliance with the most significant new requirements imposed by EPA. There are, though, a few items that EPA expects folks to have in place right away, as the effective date of the new rule was May 10th, 2024, and EPA did not provide an extended deadline for compliance. These include requirements to keep process safety information up to date and to ensure and document that the process is designed and maintained in compliance with RegAGAP. Requirement that PHAs consider additional facility siting issues such as process placement in relation to hazards posed by nearby stationary sources. Requirement for operating procedures documenting circumstances when monitoring equipment used to detect or prevent releases may be removed due to safety issues posed by natural hazards. The requirement to retain hot work permits for 3 years following completion of hot work. Updates and resubmission of risk management plans with new and revised data elements are due to EPA 4 years after the effective date, by May 10th, 2028. When it comes to enforcement, EPA has stated it plans to target facilities that it thinks pose the highest risk of causing a chemical release that's going to harm the surrounding community. It plans to do this by focusing on facilities that have a high incident rate, employers and industries with a high incidence rate, and facilities that are co-located near one or more other covered processes. As you know, OSHA's PSM standard and EPA's RMP were intended to work together and have similar requirements. OSHA is working on updating the PSM standard, but it's taking a while. Because the RMP requirements were updated before OSHA could finish revising PSM, the two standards are pretty different from one another right now. In fact, they're the most unlike each other that we've ever seen. Here are some of the most dramatic changes to the RMP and how they differ from the current PSM standard. First, one of the most significant and burdensome changes to the RMP is the requirement for a safer technologies and alternatives analysis, or an STAA. The requirement applies to certain chemical plants, petroleum refineries, and coal product manufacturing facilities, and requires employers to conduct an analysis as part of their PHAs to think about and document the possibility of using inherently safer technology or design, passive measures, active measures, and procedural measures. OSHA's PSM standard does not contain any STAA requirements yet, but OSHA plans to add the STAA requirement to the PSM standard when it revises the rule. A subset of processes at refineries and chemical plants, including those with HF acid alkylation covered processes, facilities with processes in NAICS 324 and 325 that are located within 1 mile of another source within the same NAICS code, and that have past RMP reportable accidents, must also conduct inherently safer technologies and designs, or IST-ISD, practicability assessments, and you need to document justifications when recommendations from those assessments are not implemented. Following each STAA, this same group of facilities needs to implement at least one passive measure, such as pressure vessel designs, dikes, berms, or blast walls, every PHA cycle. If no passive measures or inherently safer design technology or design is implemented, an equally protective, active, or procedural measure must be adopted. These provisions are not yet included in OSHA's PSM standard, but are under consideration for addition to the standard. Employers must consider risks related to natural hazards and potential power loss in their PHAs, including weather anomalies, environmental and geological phenomena such as wildfires, earthquakes, and extreme weather caused by climate change. Employers must also ensure monitoring equipment related to the prevention and detection of accidental releases from covered processes has standby or backup power to provide continuous operation. Should you decide not to adopt a hazard recommendation, here again, you need to explain that decision in writing in your PHA. OSHA's PSM standard does not include provisions related to natural hazards yet, but the agency proposes to add considerations for natural hazards when it revises the rule. On to facility siting. Employers need to consider facility siting in detail, considering the placement of processes, equipment, and buildings. Employers must also assess the hazards posed by other nearby stationary sources, as well as the accidental release consequences posed by a process's proximity to the public. Here again, if a recommendation is not adopted, it must be addressed in writing in your PHA. Of course, we already include facility siting in PSM PHAs, but the requirement to include an explanation if we fail to adopt a recommendation is not there yet. But of course, there's plans to add it when the PSM standard is revised. When a facility has an RMP reportable accident, the next scheduled compliance audit must be performed by a third party that meets certain criteria for competence and independence. Justification is required in the RMP when a third-party compliance audit recommendation is not adopted. And the results of the audit must be shared with the audit committee of the board of directors or its equivalent. OSHA's PSM standard does not require third-party compliance audits where a facility has experienced an incident, but this too is a planned change for the revised PSM standard. Investigation reports must now be completed within 12 months of the incident and must include factors that contributed to the incident, including the initiating event, direct and indirect contributing factors, and one or more root causes. This is another thing that OSHA is going to be adding to the PSM standard when it revises the rule. Employers must provide their employees not only with training in the risk management plan and broad access to related materials, but also with participation in risk assessment and management planning. Employee participation and consultation are required in resolving process hazard analyses, compliance audits, and incident investigation recommendations and findings. So it's pretty much every part of your program. Employees must be empowered to stop work under certain circumstances, and they must also be provided with opportunities to report any hazards that they feel are unaddressed, unreported accidents, things of that nature or any kind of RMP noncompliance, either to the facility owner, operator, or the EPA. OSHA's PSM standard only requires consultation with employees on PHAs. It does not require participation in any part of the PSM program, really, but the proposed changes to the PSM standard include most of these employee participation provisions, as well as the stop work rule. There are new community notification requirements for RMP accidents, requiring non-responding RMP facilities to develop procedures for informing the public about accidental releases, requiring release notification data to be provided to local responders, and requiring partnering with local responders to ensure community notification systems in place for notification of any RMP reportable accidents. OSHA's PSM standard does not contain a requirement like this, and the agency has not focused on anything like this during rulemaking. That said, I expect OSHA to try to realign PSM with RMP as much as it can. So I certainly wouldn't be surprised if it tried to incorporate something like this into the PSM standard too. Field exercises are required every 10 years unless local responders indicate that frequency is infeasible. The revisions also set standards for owners and operators to report upcoming emergency response exercises and prepare post-exercise evaluations. These requirements do not exist in the PSM standard yet, but OSHA plans to add them when the rules revised. A facility must promptly provide chemical hazard information upon request to the public living, working, or spending significant time within 6 miles of the facility. The information must be provided in at least the 2 most common languages in the community. OSHA's PSM standard includes no such requirement, and there has been no talk of incorporating it in PSM rulemaking. But like I said, you never know. I do think they're going to try to realign things as much as they can. There are a few other miscellaneous provisions worth discussing. The final rule added definitions for several terms that were previously undefined and revised the definition of retail facility to clarify that annual means in either the last calendar year or fiscal year for purposes of the retail facility exemption. As I mentioned before, hot work permits must now be retained for 3 years. And perhaps most importantly, EPA added several major REGA-GEP requirements that require you to keep the process in compliance with the most up-to-date applicable REGA-GEP. These requirements are not yet in the PSM standard, but OSHA intends to add all of them as well. These include process safety information. The owner or operator must ensure and document that the process is designed and maintained in compliance with recognized and generally accepted good engineering practices. The process hazard analysis must identify any gaps in safety between the codes, standards, or practices for which the process was designed and constructed and the most current version of the applicable codes, standards, or practices. The RMP must also include recommendations that were declined from the assessment of safety gaps between codes, standards, or practices to which the process was designed and constructed and the most current version. To comply with the REGA-GEP provisions, EPA emphasizes that owners or operators can only rely upon the most current version of REGA-GEP in their compliance efforts. Specifically, EPA has stated that it expects owners and operators to regularly review new and updated RegAGAP applicable to their industry and to determine where safety gaps exist within their current process. OSHA plans to require employers to keep up with evolving RegAGAP too. EPA has not issued much in the way of guidance on how employers are to comply with this rule, which is particularly troubling, given that the agency frequently relies upon the Clean Air Act's General Duty Clause, which is similar to OSHA's, to enforce the RMP rule. Using EPA's General Duty Clause, EPA is not only able to demand millions of dollars in penalties for your RMP violations, but the agency can seek criminal prosecution too. If an owner or operator knowingly violates the General Duty Clause, they may be punished by a fine or imprisonment or both. Of course, everything I just talked about may change depending on the results of the election. The last Trump administration reversed, revoked, or otherwise rolled back nearly 100 EPA rules, including many of the very same RMP requirements we're discussing today. And we know how enthusiastic he is about energy independence, which would surely also have an impact on PSM too. In fact, this process seems to have already begun. Last week, a federal appellate court granted a joint request from EPA and state and industry petitioners in a case in which industry is challenging the RMP provisions to put the litigation in abeyance for 4 months, while the agency reconsiders many of the new provisions of the rule. This is a procedural move that will ease officials' ability to roll back changes should former President Trump win re-election in November. With that, let's move on to a brief update on the PSM standard. Things are comparatively quiet when it comes to OSHA and the PSM standard. The agency's been working to revise the rule for several years now. So far, it's done a request for information, conducted a SBREFA review, and held a stakeholder meeting back in 2022. The agency is still analyzing input from the stakeholder meeting and expects to complete its analysis this year, but it's not given us any kind of indication of when the revised PSM standard may make an appearance. As I mentioned before, OSHA is planning to make many of the same changes EPA made to RMP, and the two agencies have been working closely together to realign the rules. Other major changes we can expect to see in PSM include clarifying the atmospheric storage tank exemption, retail facilities exemption, and threshold quantities for mixtures of substances listed in Appendix A of the standard, and possibly adding coverage of oil and gas well drilling and servicing operations, reactive chemical hazards, and dismantling of explosives and pyrotechnics. OSHA issued a new PSM enforcement directive several months ago, but very little about it was actually new. The document primarily consists of a compendium of previously issued standard interpretations. It also withdrew Appendix A of the previous enforcement guidance, the Program Quality Verification Audit Checklist. The now rescinded audit checklist was the basis of many employers and consultants' internal auditing programs and provided a little bit of predictability for employers facing an NEP inspection, so we were not thrilled to see the agency abandon it. Speaking of the NEP, those inspections still continue. There's not really much else new to report there. Now I will turn it over to Bita to discuss OSHA's emergency response rulemaking.
Great, thanks so much, Val. Let me see if I can get back. Alrighty. So starting with emergency response, we wanted to touch on this topic at least because we know many of you all with PSM RMP covered facilities that you have fire brigades, right? So this rulemaking substantially expands both the scope and the number of requirements in the fire brigade standard, what's currently 1910-156. So we wanted to kind of give an overview of this since this will likely have a huge impact. So the timeline. So on February 5th, OSHA published the proposed rule announcing comments were due May 6th of this year, but we, got good news. We filed on behalf of, we formed a coalition of trade groups and employers, and we filed a request for extension on March 23rd, and then OSHA extended the comment deadline by 45 days. Comments were due June 21st. Then on May 28th, we filed another request for extension, which was granted again, which is, that is very, very rare that OSHA grants even one extension, let alone two. So anyway, sort of bottom line is comments were due July 22nd. And that, that's the date that stuck. So we submitted our comments on that date. And that was over a year and a half, right? After reading the NPRM, after it came out. So we got a lot of really, really helpful feedback from industry and submitted those comments. And then just the next day, we got word from OSHA that it scheduled the informal hearing. We got hints from OSHA that it would be scheduling an informal hearing because that was requested, including on behalf of our coalition. But now we have a date for that. That's November 12th. And it might be subsequent days too, if that's necessary. So that's another chance at advocacy, and we certainly plan to speak on behalf of our coalition there. So, what are some of the proposed requirements? One theme you'll see, which is another concern of our coalition members, is sort of what I don't know, I call sort of the letter P's. It's all the programs, policies, plans, procedures, just a lot of paperwork associated with, this proposed rule. And I'll say, we're all for implementing programs, for purposes of establishing effective systems and frameworks. But a lot of what we're seeing here in this proposed rule is we're sort of just questioning the value add from a safety perspective on a lot of those requirements. It starts with this overarching emergency response program, or ERP. You basically have to set forth, what services you'll be providing, for the ones you won't, how you'll get them, things like mutual aid agreements. And it's also where you have to kind of incorporate the rest of the proposed rules requirements into this program. So, and you've also got to evaluate it every year. And I should say, while a lot of our coalition members, they have programs like ERPs already, they're not identical, I'd say, to what's in the proposed rule. So it's just going to take a significant amount of time, right, to adjust those. And again, we're not really sure what the value add is because those programs have already been effective. And so, what's the utility in making employers go back when records and history has shown that these existing programs have already been successful. So, a common theme in our comments is that the OSHA needs to provide more flexibility to employers, that this standard should really be reworked into more performance-based standard. And so, that's something that we go into detail a lot about in our comments. Another requirement is these facility vulnerability assessments. You've got to kind of identify, quantify, and prioritize your known or potential vulnerable spots. Then you've got, as we've seen with a lot of these new rulemakings, a heavy emphasis on employee participation. Then you've got an RMP, a completely different RMP. It's still a risk management plan, but that's got to be reviewed annually. And you'd have to cover just about everything. There's a lot of prescriptive language in the proposed rule, but basically you'll need to ensure that all reasonably anticipated hazards are identified and addressed, including by rating their probability and severity. You've got to come up with a priority action list, develop risk control techniques, and plan for implementation, including a post-incident evaluation of those techniques. This next bullet about PPE and such, that's stuff that you would need to include in your this version RMP, not the RMP Val spoke about. So you got to do your PPE hazard assessments, respiratory protection program. I thought this one was interesting, infection control program. Obviously, OSHA doesn't have an infectious diseases standard on the books. And then also your bloodborne pathogens. Next, where things I'd say get really complex are the medical requirements. They're very comprehensive. You've got to establish a medical evaluation program. Everyone's got to be medically evaluated at least every 2 years to kind of determine fitness for duty. Again, we didn't include a scope slide here because we just wanted to touch on this really briefly. So there are, different types of, when I'm saying everybody, it'd be covered employees under the proposed rule. But anyway, there's a lot here on medical requirements. Then we've got these pre-incident plans. You've got to include things like the location of unusual hazards and fire equipment, like your hose valves and such. And you have to review those every year when conditions change and then update them as needed. And, our coalition kind of believe that, looking at the proposed rule, that the content requirements are kind of overly burdensome and not necessary. So that was something we included in our comments as well. Incident management systems. I think this one tend to be like a little less controversial. I think, typically we got feedback from coalition members that they use these incident management systems. Then OSHA also has requirements for emergency incident operations. Again, there was a lot to unpack here. I think one thing OSHA was requiring, like ensuring, control zones are established, and we got feedback from our members saying that can't be we would love to do that, but we can't do it for every single emergency incident, which is what OSHA would require. So again, sort of that, coming at it from a practical perspective. IAPs was another hot topic. You've got to develop those for, and prioritize the life safety for each incident, and sort of utilize the information that's contained in your PIP. Then there are SOP requirements for any emergency events that were likely to be encountered. And last, these post-incident analyses to sort of develop, determine the effectiveness of your response after a significant event. And then that last bullet point, we just wanted to mention another, a very huge concern actually, is that OSHA is incorporating by reference a bunch of NFPA standards. So currently, the 1910-156 only incorporates, I think, one NFPA standard, but here I think it'd be something like 22. And so, in incorporating by reference, what that means is these NFPA standards, the mandatory parts, so those shall statements, become enforceable by law, right? So I think there are thousands and thousands, you can imagine 22 NFPA standards, there's thousands and thousands of mandatory provisions. So that was a huge concern. This standard was, as you can imagine, is very, very long, very technical, and completely reworks fire brigades. So this act, and I should mention for purposes of scope. So fire brigades obviously is focused on firefighting. This would expand into EMS, emergency medical services, and also technical search and rescue. So again, substantially expanding the scope of the standard and the number of requirements. And again, we think a flexible, fit for purpose, performance-based standard makes a lot more sense. Alrighty. So just moving on to one of my favorite subjects, I would say, and that's updates at the CSB, at the Chemical Safety Board. Before joining the firm, I was an attorney investigator at the CSB. So always excited to provide an update. So just to start, this is sort of I'd say a kudos to the agency. It had a really tremendous 2023 and it cleared its backlog of something like 20 total investigation reports right before the new year. There were 11 reports in 2023 alone, 6 that were issued in 2022. And that comes after only 3 being issued in 2021, 0 in 2020, and then 4 in 2019. And then currently the CSB only has 3 open investigations, all for incidents that occurred in 2023. So it's a little bit of a long backstory here, but basically, May 20th, 2021, Congress sent a letter to the CSB calling on the agency to clear out its investigations backlog, which at the time, as I mentioned, included 20 open investigations, including one that was at least more than 5 years old. Congress, in their letter, they asked CSB to send a timeline for completion of those. But even though there was interactions between Congress and the CSB, which I believe was during its quorum of 1 day, when there was only one board member, the chair, who was nominated by the last administration. The agency actually did not provide a timeline until October 7th, 2021. And per that very ambitious timeline with, sort of older investigations being prioritized, all open investigation reports would be completed in fiscal year 2022. So although, CSB was not able to meet its initial timeline, it updated its investigation closure plan in October 2022 and then committed to another very ambitious timeline of completing all then remaining 14 investigation reports by the end of calendar year 2023. And so this was, with a new and nearly full slate of board members and sort of renewed life at the agency under the Biden administration, including the hiring of additional staff, the CSB met that timeline. And, I'd say sort of with a celebratory announcement it was December 27th, 2023. So like literally right before the new year, that it had completely eliminated its longstanding backlog of investigations. And, to be honest, I felt relieved for the agency too. The CSB is small, right? 40 staff is sort of a high number for the agency. It has, about a $12 million budget, and that covers the whole US. So, I'd say it's sort of remarkable by any measure. Okay, so now those backlog reports, not surprising, some of them did touch on PSM issues. The agency has issued recommendations related to PSM for quite some time. So again, this was nothing new. Just for timing purposes, I won't get into these, but they're in our slides for you. And yes, we do make the slides available on our website, and so they're for you to see. So this was exciting. So on to sort of another update at the CSB. It recently developed a new work product. These are called incident reports. And this is, I'm speaking on information that we learned from interacting with the agency at the end of June on incidents that are reported under the CSB's newish, it went into effect in March 2020, accidental release reporting rule. So if you're not aware of this rule, I think many of you are, but we also hear that many aren't. So, please do reach out to us if that's the case. It's a regulatory requirement, right? It's for compliance. And if owners and operators don't report a reportable release to the CSB, then they are subject to enforcement. That's not by the CSB directly. What CSB will do is it makes referrals out to the EPA, and then the EPA enforces the CSB's reporting rule, and that can include administrative penalties and civil or criminal actions even. So again, we do want to just underscore that this is it's important for purposes of compliance, and there's certainly a lot of nuance to this rule, but just at a very, very high level, accidental releases that result in a fatality, serious injury, or substantial property damage. All of those are defined, as you can imagine, in the rule. Those must be reported to the CSB within 8 hours. And again, we could take this whole webinar kind of about the rule, and in fact, we have. We've check out some of our past webinars because we've dealt exactly with this topic. But again, I'm just going to keep moving for timing purposes. So anyway, so the goal with these incidents that are now being reported to the CSB, and just for background, when I used to be at the CSB, what the agency used to do, and I'm sure still does, is it screened its own incidents, and basically relying on NRC reports or National Response Center reports and sort of news media to identify the types of events that it might deploy to. So, but now, it has this new set of data for these reports that are proactively being made to the CSB. And the agency is hoping to prepare an incident report for each one of those. And that's a lot of reports. So I looked at the agency's latest data from July 23rd, and I think there's about 421 reported incidents. But as of June 26th, when we were interacting with the CSB, it's still figuring out how to address this existing backlog. But it's certainly it's started the process. And the vision, I'd say, for creating these incident reports is that there will be sort of a searchable database where users can look up incidents by chemical type, by type of facility, right? I think they want to put in like different filters. And that's all just for purposes of information sharing and lessons learned. Again, I'm not sure the CSB knows quite sure what the database will look like, but it certainly seems like a great vision. And here's the process. So it's basically a much faster, much quicker version of the investigation report process. So first, Office of Investigations will draft the report. And the way these are being delivered is it's really just a 1 to 2 pager, just simple format kind of draft. Then the draft goes through sort of internal reviews, internal meaning, within the agency, legal might want to review it. Then it goes through external review. So it'll go to the company to make sure, for any kind of sensitive information, CBI, factual accuracy, that type of thing. Then the company will have some time to review it and then get back. And the investigator in charge then reviews those reviewers' comments and edits and will address those issues. And then once those issues are resolved, the draft goes to the Executive Director of Investigations for review. Then the draft is sent, and I thought this was interesting, it's sent in a batch of draft reports to the board for review. So the way OSHA, the CSB is addressing these is through batches. And then the investigator in charge will then, of course, resolve any edits and comments from the board. And then sort of last step was what the executive director will post a batch of draft reports in a public database on the CSB website. So just to continue on, so like I mentioned, I really think it's interesting that these reports are going to be released in batches. The CSB and at the end of June, I believe, was putting together the first batch of 25 draft reports. And also the CSB is still not sure how the reports will be issued. Like, for example, will they be issued individually or in batches, whether there'll be separate reports or not, or whether they, want to use they have an existing database, whether they're going to be using links. So it does seem like it's still sort of in developmental stages. Timing wise, for companies sort of undergoing this exercise, it seems that it'll take at least a month and more likely 2 or 3 months from the point of the IIC, the investigator in charge, getting to review external comments before the report is issued. At least that's how things are looking at the initial outset. I imagine that once this becomes more routine, maybe that timeline could be sped up. But again, with that first batch of incident reports at the next kind of in the middle of the process stages, it may be that we see this first batch posted on the CSB's website sort of as early as this month. So definitely stay tuned. I'm sure we'll be blogging about this too, but just wanted to provide this update for now. So with that, I will pass it on to, I believe, Andrea to start getting into some California issues.
Yes, thank you, Vita. So now Rachel and I are going to go over some OSHA PSM and CalARP updates. So California has 2 PSM regulations that cover toxic, reactive, flammable, or explosive chemical releases in petroleum refineries, chemical plants, and other facilities. So 5189 is the PSM of acutely hazardous materials. And the requirement under this regulation is really similar to the OSHA requirements. except that under OSHA, employers are required to perform a compliance audit at least every 3 years, while OSHA's PSM doesn't even mention audits. And this is because California requires all businesses to have an injury and illness prevention program, which includes provisions for scheduled and periodic inspections. And so no additional requirement was included in OSHA's PSM regulation regarding those types of inspections. And then in 2017, 5189.1 was adopted, which covers the PSM for petroleum refineries. And it also covers, as such, the 14 refineries in California. So the Standards Board recently reviewed a petitioner's request to expand the scope of the PSM for petroleum refineries to include refineries that are now processing renewable feedstocks in place of petroleum. The current scope of the PSM standard references petroleum and specific North American Industry Classification System codes. And so in defining it that way, refineries processing renewable feedstocks were not technically covered by 5189.1. And the petitioner noted that although the physical properties of petroleum crude oil versus renewable feedstocks are different, the feedstock eventually, once it's processed, is processed into highly, flammable gasoline, jet fuel, and other industrial chemicals. And in its review, the division staff did acknowledge that, when the PSM standard was created, it didn't envision this rise of renewable, refineries, this whole sector for renewable refineries. So on June 20th of this year, the board denied the request for an ETS on this matter, but granted the request for OSHA to expedite normal rulemaking to add renewable refineries to 5189.1. Okay, so AB 3258 addresses the same issues as petition 601 that we just went over. Existing California law requires OSHA to adopt PSM standards for refineries, chemical plants, and other manufacturing facilities. And AB 3258 would remove the references to the existing law to petroleum refineries and petroleum refinery employers, and instead just have a reference fuels and refinery employers. The bill would also redefine refinery to mean an establishment that produces gasoline, diesel fuel, avian fuel, biofuel as defined through the process of crude oil or alternative feedstock. So AB 3258 has passed the Assembly. It then passed in the Senate with amendments. So now it's back in the Assembly for them to vote on the amendments done by the Senate. And I'll pass it on to Rachel to talk more about these issues.
And, one thing to point out, not necessarily PSM related, but regarding the petition that the OSHA Standards Board has taken up, as well as the legislation that we've been seeing go through the legislature. This also is part of the trend that we're seeing out here in California, where we see the legislature get more involved in occupational safety and health matters. So certainly if the legislature is able to pass AB 3258, that pushes it through much faster than a full rulemaking process going through the Standards Board. Of course, that does mean that, and we saw this in the workplace violence prevention statute that was just passed last year and went into effect out here in July 1, that when you're going through the legislative process, there is less opportunity for stakeholder involvement, as opposed to when you go through the rulemaking process with the CalOSHA Standards Board. So, you know, again, this is kind of part of the trend that we're seeing out here, and it's not surprising that we see the legislature getting a lot of pressure from unions to take action. CalOSHA Standards Board, much more of a slow process, and that's why we kind of see these dual tracks happening, and I expect that we're going to continue to see it happen as well. So one of the really important things that we wanted to highlight is the increased enforcement that we're seeing in CalOSHA's PSM unit. There's been a specific focus on hiring in CalOSHA generally. If you guys have been reading our blogs or attending some of our other CalOSHA webinars, you know that CalOSHA has been chronically understaffed in the enforcement area. So with district managers, as well as with inspectors. Although I know for everybody on here who has California facilities, it probably doesn't feel that way. But they have been having a huge push to recruit and to get more inspectors and more district managers. And this is no different in the PSM unit. And they have been pushed to hire. They are in fact in the middle of hiring 18 new positions, which will double the size of the unit. So of course, what does that mean? Expect increases in inspections. This past year, we've certainly seen an increase in inspections on the non-refinery side. So here in California, we have our not only are they split it somewhat into the north and the south, but also refinery and non-refinery. And we have seen a increase in those non-refinery inspections. And if you've ever been a part of one of those, you know, it's quite lengthy. It is usually takes the full 6 months. It is an onerous amount of documents. It's very time consuming for employers. And so with these additional double in size of the unit, we would expect even more of that. And the PSM unit has been somewhat going through a kind of a metamorphosis in terms of how it's structured. And this is pretty similar to what we're seeing in other units like pressure vessels, elevators, things like that, where they're having appointed managers to kind of run things more. So one of the new appointed regional managers for PSM is Andrew Kong. He has been doing refinery in the South. And so he's going to be doing some more taking on more of a role here. And that also means that if you work with Robert Salgado in the South, who's mostly been in non-refinery, he's been taking on more of a role. And you may also know Robert from, he has been a co-show for many, many years prior and has been working on inspections before that. So he's been somebody that's been around CalOSHA in a variety of different capacities for a while and is going to be taking on new roles. So the Northern California is still staying the same. We also have a new deputy chief of PSM. Well, maybe not necessarily new. He's kind of taken over this role in the past couple of years. Carl Paganelli. If you may know Carl, he is an attorney. He was a staff attorney for CalOSHA for many, many years. We worked with him closely on a variety of different cases. And so he's been really leading that unit as deputy chief, and you know, we've always had a good working relationship with Carl. I know most of the feedback that I've been hearing on other folks that are working with him is really positive. So that seems to be a good development in how PSM unit and enforcement is running out here in California. So I'll also briefly go over CalARP. You know, Valerie went over a lot of the new things that are happening with RMP, and certainly, you know, we know what happens at the federal level always trickles down to the state level, and so we anticipate seeing those types of amendments and adoption of revisions at some point coming through California as well. Now, of course, as Andrea mentioned, you know, on the PSM side, we have differences out here in California. CalARP also has its differences as well. Its chemical list is longer than RPM, and its threshold quantities tend to be lower than RPM. So if you have facilities that are in California and out of California, just make sure that you are aware that while they are there are incredibly similar, there are some differences. CalARP is enforced at the local level by CUPA, so that tends to make enforcement a little specific to the local levels, and that can be a little tricky sometimes because each local CUPA may have different interpretations and different ways of enforcement, and so that can be tricky. We have seen lately as well cooperation, or I should say maybe cooperation is a better word than coordination, between CalOSHA and CUPA when it comes to PSM inspections. Certainly we have seen CalOSHA reaching out to the local CUPA to get information from them as they do their inspection. So, you know, just remember that these are all intertwined and that these agencies are talking to each other. And I would expect that if you have a PSM inspection, that that inspector will likely, if it's out to the CUPA folks in that area as well. We've also seen an increase in anhydrous ammonia system inspections, and that has been coming from a result from various warehouse fires that have been going through the state that have happened in the past couple of years, and so we have seen an increase in inspections related to those state fires as well. So we have a couple minutes, and I think we have one question in our chat, and I think it's for Val, if she doesn't mind. And the question is, for OSHA PSM, ragged gap was typically considered to be for design. Is the same for the new RMP rule?
Yes, it is. I was saying yes, it is exactly just the same as PSM. It focuses on the design of the process and the maintenance of the process. That's when we are going to be looking at your rugged gap and trying to keep up with all of the applicable rugged gap now and all of the up-to-date ever evolving rugged gap.
Great, thank you, Valerie. And we'll do one more question, and this one is for CSB. Is there intent to be more transparent on the timeline when the work products will be published at a rolling 6 to 18 months? I am wondering if any countermeasures are in place to avoid the previous backlog.
That's a really, really good question. So I expect with this, it's already started. This board is certainly, there's a renewed emphasis on transparency. And you'll see that sort of in the public meetings. Also, CSB is issuing sort of more updates, factual updates on its reports. I think certainly that's a priority area for the agency to be more transparent overall. In terms of, the 6 to 18 months, I think those, you're probably speaking about the investigation reports. I think with those factual updates, there could be some sense of timeline in those. I'd hesitate to make any promises though. The agency is resource strapped, right? I mean, it's 40, maybe 40 staff, right? Kind of covering the whole US. So I don't think it ever sort of wants to overcommit, but I think certainly it's going to be more mindful of the number of deployments. I think what happens, right, is it's the Office of Investigations. It's a really great question. The Office of Investigations, the investigators both deploy on site, so they're the ones collecting the evidence, like OSHA inspectors, but they're doing investigations. So they collect all the evidence, they do the interviews, then they go home and they have to actually they have to write the reports as well. So I think there will be I'm sure there is sort of that more mindfulness on behalf of the board, having come through this really rigorous process of going through 20 so reports backlogged. It's certainly never the case. We talked about this a lot at the CSB. It's never the case that we want reports to be issued 5 years after the fact, right? We want these reports to go out quickly so that lessons learned are fresh, so that industry can share them. So that's always, I think it's always been the case that's the mission. It's really just a matter of sort of the practical aspect and sort of the human resources, right? Do you have people to do all the work that you need to get done? So certainly, I think that the increases in hiring, the hiring staff is going to help with that. And I think definitely the CSB has been, I'm pretty sure, even in its announcements, there is just sort of a renewed emphasis on transparency overall.
Thank you, Bita. And thank you everybody for joining today's webinar. If you liked this webinar, we have several more on our 2024 schedule on both the federal side as well as the California side. And of course, make sure that you subscribe to our blogs where we will cover all of the updates that we talked about today and anything that continues to update. We will certainly keep you apprised of it. So make sure that you subscribe to that. We have several different master classes as well as California harassment training seminar. So if you are interested in those, please reach out to us on any of those. And if you are in California, we have coming up our OSHA and California Employment Law Summit. We'll be talking about a lot of this stuff in additional detail, the rulemaking, legislation, enforcement. It's October 8th in Berkeley and October 10th in Pasadena. And we have some early bird rates for that. So please reach out if you're interested. It was a great program last year, and this will be our second annual this year. And we're really looking forward to that with some really great speakers. And here's our contact information. Please feel free to reach out to any of us if you have any additional questions, and have a great rest of your Monday.